Hello and welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. In today's video, we will discuss a recent and important judgment by the Honorable Supreme Court in the case of Angadi Chandranna vs. Shankar and Others, Civil Appeal number 5401 of 2025, arising out of Special Leave Petition, Civil, number 6799 of 2022. This case focuses on the distinction between ancestral and self-acquired property and the powers of the High Court in second appeals under Section 100 of the CPC. Let's understand the background, court proceedings, legal issues, arguments, and the final verdict step by step. The property in question is survey number 93 measuring 7 acres and 20 guntas, located in Mahadevpura village, Karnataka. The original owner, C. Tippeswamy, sold the property to his younger brother C. Jairamappa, defendant number 1, by a registered sale deed dated 16 October 1989. Later, on 11 March 1993, Jairamappa sold the same land to Angadi Chandranna, defendant number 2. The children of Jairamappa, Shankar and others, plaintiffs, filed a partition suit, OS number 169/1994, claiming that the land was ancestral and they were entitled to a share. Trial court findings. The trial court decreed the suit in favor of the plaintiffs. It held that the property was ancestral and the children had a right to demand partition and possession. First Appeal Appellate Court. Defendant number 2 Angadi Chandranna filed an appeal. The First Appellate Court reversed the trial court's decision. It held that the property was self-acquired by Jairamappa. Plaintiffs failed to prove that joint family funds were used in purchasing the land. There was no blending of the property into the joint family. Second Appeal High Court. The plaintiffs approached the Karnataka High Court under Section 100 CPC. The High Court set aside the Appellate Court's judgment and restored the trial court decree. It once again declared the property as ancestral. The Supreme Court's judgment dated 22 April 2025 in Angadi Chandranna vs. Shankar and Others, Civil Appeal number 5401 of 2025, arising out of SLP, C, number 6799 of 2022, is a reportable judgment. The case was heard by a two-judge bench comprising Honorable Mr. Justice J.B. Pardiwala, Honorable Mr. Justice R. Mahadevan. The judgment was authored and pronounced by Justice R. Mahadevan on behalf of the bench. This decision is noteworthy for its clarification on the distinction between ancestral and self-acquired property under Hindu law and the scope of High Court interference in second appeals under Section 100 of the Civil Procedure Code. Key legal issues framed. 1. Whether the land purchased by defendant number 1 was ancestral or self-acquired property. 2. Did the High Court exceed its jurisdiction under Section 100 CPC by reappreciating evidence? 3. Was the doctrine of blending applicable? Arguments. Appellant's side, Angadi Chandranna. The property was bought by Jairamappa through a registered sale deed. He obtained a loan to purchase the land and later repaid it by selling another portion. The 1986 partition deed clearly divided property, giving everyone separate rights. No evidence showed that joint family income was used. Children had no co-parcenary rights in this land. Arguments. Respondent's side, Shankar and others, claimed the property was ancestral and hence children had a birthright. Alleged that the joint family had pooled resources. Argued that by not denying family use, the property became joint by intention. Distinction between ancestral and self-acquired property. Supreme Court's explanation. In the Angadi Chandranna vs. Shankar and Others judgment, the Supreme Court clearly explained the distinction between ancestral property and self-acquired property, reinforcing well-established principles of Hindu law. The court observed that ancestral property is one that is inherited by a male Hindu from his father, grandfather, or great-grandfather, and in which his male descendants acquire a co-parcenary interest by birth. Such property must have passed undivided through generations and should not be the result of any independent effort or purchase. Simply being part of a joint Hindu family does not automatically make a property ancestral. There must be clear lineage-based inheritance and unbroken succession. In contrast, the court reaffirmed that self-acquired property is one that an individual acquires through his own efforts, skills, or resources, including through purchase from his personal income or from separate funds. Even if a person is part of a joint family, property bought in his name using separate income or borrowed money, without use of joint family funds, is considered his individual property. Importantly, his children do not get an automatic birthright in such self-acquired property. The court also emphasized that unless the owner of self-acquired property shows a clear intention to blend it with joint family property, by express words or conduct, the property remains individual. In this case, since Jairamappa purchased the land on his own and there was no proof of joint family contribution or blending, the land was declared self-acquired, and thus, the children had no right to claim partition. Supreme Court's observations. The High Court committed an error by re-evaluating factual evidence without framing a substantial question of law. Under Section 100 CPC, second appeals must only involve substantial legal questions, not facts. The first appellate court's findings were based on evidence and not perverse. The plaintiffs failed to prove blending or use of joint family funds. The doctrine of blending requires clear intent to relinquish ownership and convert self-acquired into joint property, not proved here. Final verdict of the Supreme Court. The appeal was allowed. The High Court judgment was set aside. The first appellate court's decree was restored. The land was declared as self-acquired. Plaintiffs had no right to claim partition. Thus, the decision was in favor of Angadi Chandranna. Conclusion. This case is a vital precedent in understanding the limits of appellate jurisdiction under Section 100 CPC. The clear distinction between ancestral and self-acquired property. The strict requirements of the doctrine of blending in Hindu law. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.